A routine traffic case quickly turned into a courtroom showdown when a self-proclaimed sovereign citizen refused to recognize the court's authority. But the judge wasn't buying it.
Please come up to the podium so you can be on a microphone. Otherwise, your statements won't be recognized.
I'm Anthony Meyer. And appear by special appearance to challenge jurisdiction.
Wait until you're at a microphone, sir, so you're being recorded, please.
Okay, very well.
There at the podium.
Approach special appearance only, not as the named entity.
Come on up to the microphone, please. Let me ask, are you Anthony Meyer? Yes or no?
I am Anthony Meyer and appear by special appearance to challenge jurisdiction and confirm administrative default to avoid joinder. And I am approaching under special appearance and not as the named entity.
This is the case of the People versus Anthony Meyer. Are you Anthony Meyer? Yes or no? And that will determine whether or not there's a failure to appear today.
I am, Your Honor, I stated that I am Anthony Meyer.
Okay.
Here by
So,
special appearance.
Mr. Meyer, you've already
Objection,
made your statement.
objection.
You've made your
You're
statement.
interrupting me, please.
You've already made your statement this morning. Now,
Anthony
we need to
Meyer,
reset
and
the case for
hereby
trial.
Special.
You've already
appearance.
said that, right?
I'm only here to settle the accounting.
So you have two options. You can go to trial, or you can plead guilty or no contest to the charge of no insurance. You want to have the
I'm
case
here in-
reset for trial? Yes or no?
I'm here in honor to settle the matter.
Then let's settle it. If you want to know proof of insurance, you can take that. If you want to go to trial, you can do that.
Can you have the DA read the charges into the record?
You're charged with no proof of insurance. You can plead guilty, no contest, or proceed to trial again.
I don't see any proof of the charging instrument and
You
or
were
any of
issued
the
a summons and
certified
complaint
accounting.
that's adequate to inform you of the charges. You test or stand by the not guilty plea that was entered by the court on your behalf, and we will reset the case for trial. How would you like to proceed?
Before this court can proceed, the plaintiff must rebut the administrative judgment and provide a verified claim by the party with firsthand knowledge.
That's inaccurate. We're going to set it for trial again.
Jurisdiction remains unanswered, and there is an unrebutted administrative judgment on the record, and I request for dismissal.
A motion to dismiss denied. Let's set it for jury trial on, we've got speedy trial restarting as of today's date.
Your Honor, for the record, I do not see the officer present in the courtroom, and without a sworn complaining witness with firsthand knowledge, I move the matter to be dismissed.
Motion to dismiss is denied. The officer does not have to be here today. We're going to set it for jury trial on May 7th
I have
at 8:30.
I've yet to see an offer from the DA. Can Mr. Epson please read the charges into the record?
The offer is no proof of insurance.
Okay,
guilty.
can I see those charging instruments and the certified accounting for that?
We're done.
I do not see the certified accounting for the charges or the charging instruments, and I again request dismissal. I'm here by special appearance to confirm the administrative default. I've given you guys the motion, or sorry, the notice. I've given you guys the notice, order, and the motion to dismiss, and I've also put into the record an acceptance of offer. And again, Anthony Meyer, the living man, accepts the presentment of the offer for the case number 23T0294 to set off, settle, discharge, and close all accounts, including but not limited to the equitable subrogation, IRS 941, the 941V, the 1099A, C, and OID, or supplied supersedes bond. I, Anthony Meyer, the living man, does not consent to go to prison on behalf of the named defendant, estate Anthony Janae Meyer.
Mr. Meyer, your motions are non-persuasive and essentially gibberish. Motions to dismiss are denied. The case is being reset for jury trial. You've seen what happens if you pull this at a jury trial. It will register as a failure to appear. A new warrant will issue, and we'll keep going through this
I'm here in
until
honor.
you show up and acknowledge in front of a jury that you are Anthony Meyer. So again, you can go back to trial. We've set a trial date, or you can plead guilty or no contest. Last chance. You want to set it for trial? Yes or no?
Again, I'm here by special appearance to challenge
We're
the
going to
jurisdiction.
trial May
and to confirm
7th
the
at
administrative
8:30. We're
default.
going to do a status pretrial conference with a mandatory appearance.
I'm here in honor. And the DA is yet to present me anything, no offer, has showed no proof. Officer is nowhere to be seen. I'm present right here in front of you. You're saying that I'm not here. I'm
Judge, for the
telling you that I'm
record-
here
For the
especially.
record, the officer was here
No,
on
he wasn't.
Thursday. Both officers came in one came in from Florissant, one came in from Park County.
The officer
Maybe
does not,
these
Mr.
officers,
Meyer, the officer
but
does
for
not
officer-
have to be here today.
He's
You
never
are-
been here for any,
He
for
was-
not the arraignment, not for the hearing, nor was he here for the jury. And then you
Had-
said that I wasn't here last time when I was present right here in front of you,
I called
telling
for
you.
Anthony Meyer twice. You refused to have a seat, so I found you failing to appear to be tried.
And I was telling you that I'm
Had
here by
you taken
special
your
appearance.
seat, had we sworn a jury and had the officer not appeared, it would have gotten dismissed. That didn't happen because you failed to take your seat at the defendant's table. So
I was willing to take my seat,
No,
Your
you
Honor.
were
I just
not.
wanted to let you know that I was here by special appearance to settle the matter.
Okay.
And again, today I'm here only to settle the matter.
the only way to settle it is to plead guilty or no contest.
Are you practicing law from the bench?
No.
No, I'm
Okay,
making the
we're
offer.
done.
Entered a plea on my behalf the first time.
As the statute authorizes, if someone refuses to plea, the court can enter a not guilty plea. So head down the hall, they'll get your paperwork. We'll see you here in person, March 4th at 3 o'clock for pretrial conference. And the case is set for jury trial, May 7th at 8:30.
You guys have my offer, and so I'm waiting for the certified accounting and for the instrument for this to be able to proceed forward. So
Don't hold your breath. Go down the hall to the
We'll be
clerk's
the same.
window. Thank you.
Thank you, Your Honor.
All right, let's go to Mr. Anthony Meyer. Case number 2023 T294, appearance on bond. Case is currently set for jury trial. Take two on May 7th at 8:30. Good morning, Mr. Meyer.
Good morning, Your Honor.
Any questions to begin with?
I, Anthony Meyer, am appearing specially, not generally, on behalf of the named defendant estate, also known as Anthony Janae Meyer, here to challenge jurisdiction and to confirm the administrative default and to avoid joinder. And only here to settle the accounting.
So to summarize your options again, of course, you're presumed innocent.
As the hearing continued, the defendant repeated the same legal arguments over and over, but the judge calmly explained why none of them had any legal basis, and every motion was denied.
Guilty or no contest to the charge. Mr. Ibsen, is there a stipulated plea offer regarding any potential jail time?
Judge, I was going to make the defendant a plea offer actually, I was going to offer a deferred judgment to no proof of insurance for a year with 60 days jail suspended on condition that he provide proof of insurance to the court every month. Court of probation.
So there's a plea offer that includes a deferred judgment with required ongoing proof of insurance, or you can plead guilty or no contest with a fine and court costs, 4-point assessment against your driving privileges, or of course, carry on with the jury trial scheduled in May. Mr. Meyer, of those options, do you want to continue with the trial setting?
I would say at this time, I have put in the notice motion in order. And before the court could proceed, the plaintiff must rebut the administrative judgment and provide a verified claim by the party with the firsthand knowledge.
I didn't
And
understand
would
that.
like to see if I could have a written response to my offer and 72 hours to review with my attorney.
You do have the right to discovery. Have you requested that from the DA's office?
I have not.
So you can make a request for discovery. That'll give you the police reports and other discoverable information in the file, any body cam video of the incident, anything that the state has to provide to you under Rule 16. Then you can assess that evidence and decide how best to defend yourself at trial if you want to continue with the trial. You do have the right to confront any of the state's witnesses. That right means that at trial, those witnesses would be called, put under oath, and you could cross-examine them. You do have the right to present your own evidence, though you don't have to. It's the state's burden to prove the charge beyond a reasonable doubt. You don't have to take the stand or call witnesses, but you of course have the right to if you choose to. Other than that, the court has denied your motions to dismiss. The complaint filed in the case is adequate under Colorado law to advise you of the nature of the charge, date, place, and time. So we are going to proceed to trial unless you choose to take a different path. Any additional questions today?
I would just say that I still don't understand the charges. I haven't seen the charging instruments and or certified accounting. And at this time, jurisdiction remains unanswered. And there's an unrebutted affidavit or administrative default judgment on the record. And again, I just request dismissal.
The motion to dismiss is denied. The complaint that you were issued by the officer is adequate to inform you of the charge. That's a charge of operating a vehicle without showing proof of insurance. It indicates the date, place, and time, that being within Park County, thus conferring jurisdiction on this court. So the next court date,
Shows there was a pre-trial for tomorrow. I'm not sure if that could be pushed out or could also be pushed to Zoom. I actually don't reside in this state. I'm kind of here because I have to be. And so, yeah, either if I could do a Zoom for tomorrow and or it could be pushed out a little bit. I guess there's a few additional things I could request and or file.
okay. So you're currently on bond. The court, Mr. Ibsen, any objection to modifying bond to allow Mr. Meyer to leave the state
No, sir.
pending the trial?
No,
Okay, so the bond is not forfeit. It continues. That's $1,000 cash bond posted last time. We'll continue the bond until the case is resolved. Modify the bond to allow you to leave the state. Are you residing in Arizona?
Florida.
Florida now, okay. The next court date that the court is showing is the jury trial. Well, we've got a pretrial readiness tomorrow, okay, that's what you're referring to. I propose we vacate that.
Okay.
And we just leave it on for trial May 7th at 8:30. You would have to be here in person for that.
Oh, yeah. And could I add one more thing?
Sure.
I would like to motion and order this court to revoke and revest the court's case trust securities. And I'm motioning and ordering the court and the state to produce the IRS 1099-A QSIP, bid bond, performance bond, and payment bonds for set-off, settlement, adjudication, adjudicate all claims, balance all the accounts to zero, discharge and close all accounts, and remain funds to me and dismiss the case with prejudice. Just unless I can get the certified accounting, just because this would be a concealment of my tax records.
I have no idea what you're asking. So the motion's denied as inapplicable, incomprehensible, and unpersuasive entirely. So the case remains set for jury trial May 7th at 8:30. Next time, if you're not here, a warrant issues. If you're here and refuse to acknowledge your presence, but I know you're here, the issue would be either to issue a warrant, take you into custody, or proceed with you in absentia, noting that you're present but refusing to participate. So you can show up and participate. You can show up and refuse to participate. In other words, not have a seat at the defense table and acknowledge that you're the individual named Anthony Meyer. And then at that time, I'll decide whether to put on the trial anyway, or take you into custody again and go through the whole bonding out and keep this cycle going.
I have the right.
Or you can refuse to come and we'd issue a warrant.
I have the right to appear specially and not generally, though, correct?
No.
No, you have to appear as Mr. Anthony Meyer. If you do not, but I know you're sitting in the audience, I may decide to put on a trial with you in absentia that you're refusing to participate but are present, or I'll issue a warrant and have you taken into custody. Those would be the options if you're not willing to have a seat at the defense table acknowledging that you are Mr. Anthony Meyer. Okay?
Okay.
Any other questions today?
Judge, just for the record, and I want to make sure the record's clear on this. Ms. Lindsay checked our records. We have given Mr. Meyer discovery in this case.
Okay. Thank you, sir.
Okay.
So that'll do it for today. Head down the hall if you want a printout of your next court date. Of course, that is the jury trial. You need to be here at 8:30, May 7th, acknowledging that you are Mr. Anthony Meyer, the accused. If you refuse to do so, I've explained what the court's options are limited to.
In the end, the court refused to dismiss the case and scheduled it for trial. The judge made one thing clear: courtroom arguments must be backed by law, not personal theories. Do you think the judge handled this case fairly? Let me know in the comments.